Hello again, ladies and gentlemen. In our last episode, I showed you how to draft a simple summons. Today, we're going to step it up a notch and draft a combined summons together. Not all combined summonses will look the same. There are so many different types of claims that can affect the way you formulate your particulars of claim. For example, the particulars of claim in which a divorce is sought will differ to the particulars of a damages claim. Today, we'll be drafting a combined summons where the cause of action is based on the breach of an agreement. The relief sought will be the payment of an amount, together with interest and costs. The summons. A combined summons consists of a summons and the annexed particulars of claim, whereas in a simple summons, the brief particulars of the claim are set out in the summons itself. In the combined summons, the particulars of claim are set out in much greater detail in the annexed pleading known as the particulars of claim. Considering the above, the summons itself will look slightly different to the simple summons. I've already mentioned that we'll be issuing summons due to the breach of a written agreement. Let's pretend that in terms of the agreement, our client would render services for the defendant at an agreed price. The defendant breached the agreement, and due to said breach, 500,000 Rand is due to our client. Due to the amount claimed, we will be in the High Court. Let's go with Joburg this time. After we have drafted the High Court combined summons, I will briefly show you the respects in which a combined summons in the Magistrate's Court will differ. High Court combined summons. The heading. The heading of your summons will look exactly the same as the heading of a simple summons, except above the court citation, we'll put the words combined summons. In our last episode, the parties were both natural persons. Let's go with two companies this time. Our client will be ABC Pty Limited, and the defendant will be XYZ Pty Limited. Remember to include the parties' registration numbers when identifying them as plaintiff and defendant. Again, this is not strictly necessary, but if you have the information on file, just do it. Also note that many companies have a registered name as well as a trading name. For example, XYZ Pty Limited could trade as XYZ Services. If you have this information in your possession, cite both the registered and trading name. Have a look at how we would cite a defendant with both a registered and trading name. Insert a horizontal line after the parties' names and you have your heading. For more information on a summons heading, go watch our episode on the simple summons. It should be displaying at the top right of this video. The instruction to the sheriff. The summons part of the combined summons is once again an instruction to the sheriff to inform the defendant of certain particulars and to serve a copy of the summons on it. So we will instruct the sheriff or the deputy to inform who? Well, the defendant obviously. Remember, the rules prescribe certain information that must be included in the citation of the parties. The defendant is a company. Let's say it has its registered address and principal place of business at 14 Cadaver Road, Randburg, Johannesburg 2167, and its domicilium Sitandi et executandi at 89 Walker Street, Sandton, Johannesburg. Let's stop for a second. In case you did not watch our episode on jurisdiction, let me explain what a domicilium Sitandi et executandi is. A domicilium Sitandi et executandi is a Latin legal term meaning the address nominated by a party in a legal contract where legal notices may be sent. We refer to this address as a party's domicilium. A party's domicilium is not a jurisdictional ground unless it is also registered address, principal place of business, residence, etc. of the defendant. When I use Latin in any documents, pleadings, etc., I always put it in italics. You are not, however, required to. As the particulars of claim will be attached to the summons, we will only confirm the court's jurisdiction in the particulars and not in the summons itself. In the defendant's citation, we need to include the fact that the defendant is a company duly registered and incorporated in terms of the company laws of the Republic of South Africa. We will again say that the full and further particulars of the defendant are unknown to the plaintiff. Our citation of the defendant will therefore look as follows. So, what are the differences between the defendant's citation here and that in the previous episode? Well, in this example, the defendant is a company, so we must allege that it is registered and incorporated in terms of the company laws of South Africa. That is the only real difference. The reason why we make reference to a domicilium address is because our cause of action is based on the breach of a contract. 99% of contracts will have a domicilium clause. You can also be a natural person and have a domicilium. It just depends on the agreement concluded between the parties. Although not relevant for this episode, be very careful with electing your domicilium address. You should know exactly what to do if there's more than one defendant, as this was discussed in our previous episode. We now need to give the sheriff the plaintiff's information so that he can inform the defendant who the party is that is instituting legal action against it. As is the case with the defendant, the plaintiff's details will be entirely made up. So, the sheriff must inform the defendant that ABC Pty Limited, registration number whatever, a company duly registered and incorporated in terms of the company laws of the Republic of South Africa, with its registered address and principal place of business at 40 Hound Street, Rampark Ridge, Johannesburg 2198, in brackets, the plaintiff. When citing the plaintiff, do not state whose full and further particulars are known. Think about it, that wouldn't make any sense. It's your client. As usual, if there is more than one plaintiff, you'll merely cite the first plaintiff and then the second plaintiff and so on. You can then either start immediately after the plaintiff, which is in brackets, in the same paragraph, or continue in a new paragraph. But the next thing we need to state is, hereby institutes action against the defendant, in which action the plaintiff claims the relief on the grounds set out in the particulars annexed hereto. So, instead of setting out the brief particulars in the summons, like we did in the simple summons, we will merely instruct the sheriff to inform the defendant that he can find the particulars of claim in the annexure to the summons being the particulars of claim. The plaintiff's citation and reference to the particulars of claim will look as follows. Regarding our further instructions to the sheriff, we will once again have the sheriff inform the defendant that if it wishes to defend the claim, it shall, within 10 days of the service upon it of the summons, file with the registrar of the court at, and then you must insert the court's address, notice of its intention to defend, and serve a copy thereof on the plaintiff's attorney, which notice shall give an address, not being a post office box or poste restante, referred to in Rule 19, Subsection 3, for the service upon the defendant of all notices and documents in the action. You know already that if a simple summons is defended, the next step would be for the plaintiff to deliver a declaration. That is not the case with the combined summons. After the defendant delivers a notice of intention to defend, it has 20 days to deliver either a plea, exception, or application to strike out, with or without a counterclaim. Therefore, we need to have the sheriff inform the defendant that this is what it may do. The two aforementioned instructions to the sheriff will look as follows. We then need to do a final instruction to the sheriff, in which he is to inform the defendant that if it fails to deliver a notice of intention to defend, judgment may be taken against it. We don't stop there though. The defendant needs to be informed as well that even if it does deliver a notice of intention to defend, but fails to deliver a plea, exception, or application to strike out, judgment may also be taken against it. And then of course, the sheriff must be instructed to actually serve a copy of the summons on the defendant. The final instructions to the defendant may be worded as follows. Signing off. If you would prefer electronic service of future pleadings and notices, insert the usual clause. It will look as follows. Remember, in the High Court, this paragraph is based on Rule 17, Subsection 3D, and in the Magistrate's Court, it is based on Rule 5, Subsection 3B. Also remember to include your email address and file reference number. Indicate the date on and the place at which the summons was signed. We then need to make provision for the signature of the registrar, after which you will sign off and add the necessary details. The signing off step will look as follows. That's where the summons part will end. We then need to draft the particulars of claim, which will be annexed to the summons. Particulars of claim, High Court. Before we start drafting our particulars of claim, a full understanding of the following rules is imperative. In terms of Uniform Rule 17, Subsection 2A, in every case where the claim is not for debt or liquidated demand, the summons shall be near as may be in accordance with Form 10 of the first schedule to the rules, to which summons shall be annexed a statement of the material facts relied upon by the plaintiff in support of his claim, which statement shall inter alia comply with Rule 18. All that this provision is saying is that a combined summons consists of the summons as well as the particulars of claim. In terms of Uniform Rule 18, which is paraphrased, the particulars of claim shall be signed by both an advocate and an attorney, or, in the case of an attorney who has the right of appearance in the superior courts, only by such attorney, or, if a party sues or defends personally, by that party. The particulars of claim is a pleading, and pleadings in the superior courts may only be signed by an attorney with right of appearance, alternatively an advocate. The particulars of claim shall be divided into paragraphs, including subparagraphs, which shall be consecutively numbered and shall, as nearly as possible, each contain a distinct averment. The particulars shall contain a clear and concise statement of the material facts upon which the plaintiff relies for his claim, with sufficient particularity to enable the defendant to reply thereto. A plaintiff who in his particulars relies upon a contract shall state whether the contract is written or oral, and when, where, and by whom it was concluded. And if the contract is written, a true copy thereof, or of the part relied on in the pleading, shall be annexed to said particulars. It shall not be necessary in the particulars of claim to state the circumstances from which an alleged implied term can be inferred. I've only set out the rules relevant to the particulars of claim in our example. Certain claims are subject to further rules, such as one for damages. We will be drafting in a future episode a combined summons where we claim damages. Heading and format. We will title our particulars of claim as Particulars of Claim, which should be in all caps and underlined. You do not need to add to the particulars of claim the same detailed heading we set out in the summons. The particulars of claim will be attached to the summons, so there's no point repeating the case number, parties, names, and so on. After the heading, which is particulars of claim, we can get straight into drafting. As already mentioned, Uniform Rule 18 requires the particulars of claim to be divided into consecutively numbered paragraphs, including subparagraphs, with each paragraph, to the extent possible, containing a distinct averment. Although not required, when I draft particulars of claim, I include subheadings. Often your particulars of claim can be very extensive, so using headings can break it up into sections. The subheadings I generally use when it comes to claims of this nature are the following: the parties, jurisdiction, the agreement, plaintiff's obligations, and breach. You can, of course, use whatever subheadings you think would be appropriate. After the final subheading, we will obviously have our prayers. I'm going to break down the particulars of claim by discussing each heading separately. First, as always, the parties citation. The parties. Type and underline the heading, the parties. As required by Rule 18, our paragraphs need to be numbered. So, after the parties heading, start a new paragraph with the number 1. In paragraph 1, we need to cite the plaintiff, and in paragraph 2, we need to cite the defendant. If there are numerous parties, you will separately cite all the plaintiffs first and then cite the defendant. For example, paragraph 1 would include the citation of the first plaintiff, and paragraph 2 the citation of the second plaintiff, and so on. As we've already cited the parties in the summons, citing them again in the particulars of claim is easy. At paragraph 1, type the plaintiff is, then go to your summons and copy your plaintiff's entire citation excluding the plaintiff in brackets. Paste the copied citation straight after the words the plaintiff is. We now have our plaintiff citation, the paragraph of which will state the plaintiff is ABC Pty Limited, registration number whatever, a company duly registered and incorporated in terms of the company laws of the Republic of South Africa, with its registered address and principal place of business at 40 Hound Street, Rampart Ridge, Johannesburg 2198. We'll do the same with the defendant. The paragraph containing the defendant's citation will state the defendant is XYZ Pty Limited, registration number whatever, a company duly registered and incorporated in terms of the company laws of the Republic of South Africa, whose full and further particulars are to the plaintiff unknown, with his chosen domicilium citandi et executandi at 89 Walker Street, Sandton, Johannesburg 2164, and registered address and principal place of business situated at 14 Cadaver Road, Randburg, Johannesburg 2167. Court's jurisdiction. Remember from our previous episode that if you wish to confirm the court's jurisdiction in the defendant's citation paragraph, you may do so. After the defendant's addresses, state which addresses fall within the jurisdiction of the above honorable court. It is also possible that only one of the addresses mentioned fall within the court's jurisdiction. In such an instance, you will refer to either the former or the latter address falling within the court's jurisdiction. If you find this tricky, or if jurisdiction is founded on any other ground, such as cause of action, do a separate paragraph. In our example, jurisdiction will be founded on the area in which the whole cause of action arose, in addition to the residence of the defendant. If you don't understand how a company can reside somewhere, check out our episode on jurisdiction. Before we proceed with our paragraph concerning jurisdiction, type in bold and underline the heading Jurisdiction. Below our new heading, we will insert the paragraph concerning jurisdiction. Paragraph 3 states as follows. The above Honourable Court has jurisdiction to hear this matter as the defendant's registered address and principal place of business are located within the court's jurisdiction. Furthermore, the whole cause of action arose within the court's jurisdiction. Our citation of the parties and the jurisdiction paragraph will look as follows. The facts. Whenever I draft a summons where the cause of action is the breach of a written or oral agreement, after the paragraphs in which the parties are cited and jurisdiction confirmed, I set out the facts surrounding the agreement and the terms of the agreement itself. The full set of facts will, however, be set out throughout the remainder of the particulars of claim. Take note that you are to set out the facts as according to the plaintiff and not purely the undisputed facts. Before we set out the facts of this matter, familiarize yourself with the following provisions of Uniform Rule 18 which are applicable to this type of claim. 18 Subsection 4. Every pleading shall contain a clear and concise statement of the material facts upon which the pleader relies for his claim, defense, or answer to any pleading, as the case may be, with sufficient particularity to enable the opposite party to reply thereto. 18 Subsection 6. A party who in his pleading relies upon a contract shall state whether the contract is written or oral, and when, where, and by whom it was concluded, and if the contract is written, a true copy thereof, or the part relied on in the pleading, shall be annexed to the pleading. 18 Subsection 7. It shall not be necessary in any pleading to state the circumstances from which an alleged implied term can be inferred. When setting out the facts, the first step is to reference the agreement and its terms. The agreement. After the paragraph on jurisdiction, insert another heading simply called the agreement. Underneath the heading, we'll start at paragraph 4. This next section sets out the foundation of our claim, so make sure the contents are clear and concise. First, we need to ask ourselves, what did the defendant and the court need to know about the agreement and the circumstance surrounding the conclusion thereof? Well, let's think. In our example, our claim is based on a written agreement. Therefore, we need to make sure that we comply with Rule 18, Subsection 6. So we need to indicate the following. That a written agreement was entered into between the parties, the type and nature of the agreement, the date on which the agreement was entered into, the place at which the agreement was entered into, the identity of the persons acting on behalf of the parties. Remember, both parties are juristic persons, so they cannot physically sign an agreement. A representative of each party would have had to sign on the juristic entity's behalf. I like to get all of the above out of the way immediately in the first paragraph, being paragraph 4 in our example. This paragraph will therefore state, remember I'm making up the facts, on or about 1 February 2021 and at Rampart Ridge, the plaintiff, represented by Simon Goku, duly authorized, and the defendant, represented by Bill Burr, the sole director of the defendant, concluded a written transport service agreement, in brackets the agreement. A copy of the agreement is annexed here to marked A, and the contents must be read as is specifically incorporated here. In one single paragraph, we have essentially complied with Rule 18.6. Next up, we need to set out the material terms of the agreement. Material terms are the essential terms relevant to our claim. Please do not type out every single term of the agreement. If it is irrelevant, leave it out. So we'll start by saying in paragraph 5 that the salient and material terms of the agreement are inter alia, and then we'll proceed to set out said terms. Take note that you can also distinguish between express, implied, and tacit terms, should you wish. Just briefly, express terms are the terms specifically set out in the agreement. Implied terms are not expressly set out but are implied by law, and tacit terms are terms not expressly set out but implied by the facts. More on this in a later episode. Paragraphs 4 and 5 will look as follows. We will set out the material terms and conditions of the agreement from paragraph 5.1 onwards. As I'm making up the facts here, the material terms and conditions of our agreement will not be extensive. When setting out the material terms of the agreement, the most important terms will be regarding the nature and purpose of the agreement, the duration of the agreement, the service costs and payment terms, the obligations of the plaintiff arising from the agreement, domicilia of the parties, breach and cancellation of the agreement. Terms pertaining to the above are the most important. This does not necessarily mean, however, that they are the only terms you must reference in the particulars. If the agreement contains other important terms relevant to prove the claim, mention them. I need to make up the terms of the agreement so that we can continue drafting our particulars. The material terms of the agreement will be as follows. With regards to the nature and purpose of the agreement, let's say that the plaintiff would provide transport services to the defendant, and in particular the defendant's employees at an agreed price. The duration of the agreement will be for a period of 1 year. The price of the services will be 600,000 Rand for the first 6 months and 400,000 Rand for the remaining 6 months, both amounts being VAT inclusive. The service fee will be all inclusive. Usually, there are quite a few clauses pertaining to payments in an agreement. For example, all payments will be free of exchange, set-off and deduction. Payments may be appropriated by the plaintiff to any debts owed to it, the interest rates on any late payments, etc. We will include some of these terms in our agreement. Mention of the plaintiff's obligations can be brief, as they are not entirely relevant to our claim. Although brief, we need to still mention them, as we will allege compliance with said obligations towards the end of our particulars. Let's say the plaintiff's obligations, as set out in the agreement, are to provide the service 6 days a week, to be punctual, and to ensure the vehicles are in a roadworthy condition. 99% of agreements will have a domicilium clause. In our particulars, we must make mention of the defendant's chosen domicilium as set out in the agreement. When citing the defendant in the summons and the particulars, we make reference to the defendant's domicilium address. So we need to show the court how we determine that the mentioned address is the defendant's domicilium. Terms pertaining to breach are extremely important. We cannot allege that the defendant breached the agreement as set out in the breach clause if we do not actually cite the provisions pertaining to breach. Most agreements set out the types of acts and omissions that constitute a breach, as well as the ways in which the breaches can be remedied. Take note that where there is no breach clause, various rights and options will only become available to the aggrieved party if the breach is material in nature. More on this another time, as in our example, the agreement has a breach clause. The breach clause in our agreement makes reference to the grounds for breach, the ways in which a breach can be remedied, the rights of the aggrieved party, the payment of legal costs in the event of enforcing a breach, as well as interest payable on outstanding debt. In light of the above, let's set out the made-up material terms in our particulars of claim starting at paragraph 5.1. Term regarding the nature and purpose of the agreement. The plaintiff would provide a transport service to the defendant at the defendant's special request, in brackets the service. In particular, the plaintiff would transport the employees of the defendant to and from various locations on a daily basis, subject to the terms and conditions of this agreement. Term regarding the duration of the agreement. The plaintiff would provide the service for a period of 1 year, the service period, commencing on 1 March 2021, the commencement date, and terminating on 28 February 2022, the termination date. Terms regarding the service costs and the payment thereof. The defendant shall pay to the plaintiff an amount of 1.2 million Rand, including VAT, for the service fee, which amount shall be payable as follows: 600,000 Rand prior to the commencement date, and 120,000 Rand per month from 1 October 2021, and thereafter on the first day of each subsequent month, with the last payment being payable on 1 February 2022. The service fee would be all-inclusive, and any additional costs including, but not limited to, fuel, vehicle maintenance, and toll fees would be borne by the plaintiff. The defendant would make all payments in terms of the agreement without demand, free of exchange, and without deduction or set-off for any reason whatsoever. The plaintiff would be entitled, in its sole discretion, to appropriate any amounts received from the defendant towards the payment of any cause, debt, or amounts owing by the defendant to the plaintiff in terms of the agreement, without prejudice to any of the other rights of the plaintiff, from due date to date of payment. The defendant shall pay interest at the annual prime rate of interest as determined by Standard Bank of South Africa Limited from time to time during the period while the payment is outstanding on all amounts due by the defendant to the plaintiff in terms of or arising out of the agreement. Term regarding the obligations of the plaintiff arising from the agreement. The plaintiff would provide the service from Monday to Saturday between the hours of 6 and 6 p.m. every week for the duration of the agreement. The plaintiff would ensure that his drivers were punctual and his vehicles in an acceptable roadworthy condition. Term regarding the domicilio of the defendant. The defendant chose an address specified in 2 above for service of documents and notices, which is the domicilium secundii et executandi, for all purposes of the giving of any notice, the serving of any process, and for any other purpose arising from the agreement. Terms regarding the breach and cancellation of the agreement. Should the defendant, inter alia, fail to pay the service fee or any part thereof on due date, or breach any other term of the agreement and fail to remedy the breach within a period of 7 days after receipt of notice to that effect from the plaintiff, then the plaintiff may, without prejudice to his other rights and remedies against the defendant, claim immediate payment and or performance by the defendant of all of the defendant's obligations under the agreement, whether or not the due date for such payment and or performance had arrived, and cancel the agreement and claim damages. In the event of a breach as aforesaid, the plaintiff would be entitled to recover all legal costs incurred by it, including attorney and client charges, tracing fees, and such collection commission as the plaintiff is obliged to pay to its own attorneys from the defendant. The cost would include, but not be limited to, costs incurred as from the date that the plaintiff instructs its external attorneys for dispute resolution, debt collection and or agreement enforcement. Without prejudice to any of the other rights of the plaintiff, from due date to date of payment, the defendant shall pay interest at the annual prime rate of interest as determined by Standard Bank of South Africa Limited from time to time during the period while the payment is outstanding on all amounts due by the defendant to the plaintiff in terms of or arising out of the agreement, including any monies disbursed by the plaintiff on behalf of the defendant. The terms as set out in the agreement will look as follows. And just like that, we have our terms and conditions. Plaintiff's obligations. After we have set out the material terms of the agreement, we need to allege that the plaintiff complied with all its obligations in terms of and arising from the agreement. So, after the final paragraph pertaining to the agreement terms, insert a new subheading called Plaintiff's Obligations. All we need to do under this heading is to state what I've just said, namely that all material times the plaintiff complied with all its obligations in terms of and arising from the agreement. This paragraph indicates to the court that the defendant's breach was not justified by any failure of the plaintiff to comply with any of its obligations. It also gives the defendant an opportunity to admit or deny whether the plaintiff did in fact comply with said obligations. This paragraph and heading will look as follows. If you want, you can go into greater specifics about the actual obligations with which the plaintiff complied. For example, you could state that the plaintiff was always punctual and that the vehicles were always in a roadworthy condition. It is, however, not necessary. Breach of the agreement. We've now set out the terms of the agreement and alleged that the plaintiff complied with all its obligations and terms thereof. The only thing we have left to do is to set out the particulars of the defendant's breach. So, let's insert the final subheading, Breach of the Agreement. Below this subheading, we will proceed to set out the breach in very simple terms. Before we do so, we need to ask ourselves, how did the defendant breach the agreement? Well, the defendant breached the agreement by failing to pay to the plaintiff the service fee on the due date. It's that simple. Although the defendant did make payments of 700,000 Rand, it still did not pay the service fee, as the service fee is 1.2 million Rand, and that amount has not been paid. We therefore need to mention this in our particulars, as well as the fact that the outstanding amount has still not been paid. It is imperative that we attach some sort of proof that 500,000 Rand remains outstanding. Our proof will be in the form of a statement of accounts. We can set out the defendant's breach in a single paragraph. So paragraph 7 should read as follows. The defendant breached the agreement by failing and or refusing to make payment to the plaintiff of the service fee in the amount of 500,000 Rand, which amount is currently due, owing, and payable. The statement reflecting the aforesaid amount is annexed here to marked B. It's that simple. We do not need to go further than that in the particulars of claim. Depending on the contents of the plea, we'll be able to deliver a replication in response thereto, which is not always necessary. In a matter such as this one, we would prefer to proceed to summary judgment. What we should do, however, is draft a paragraph in which we basically confirm the amount outstanding, and if the outstanding amount has been previously demanded from the defendant, we must mention this. In our example, let's pretend that we previously sent a letter of demand to which we received no response. Our paragraph 8 will therefore state, the defendant is therefore indebted to the plaintiff in the amount of 500,000 Rand, which amount the defendant has neglected and or refused to pay, notwithstanding demand. It is also advisable to indicate the date on which the letter of demand was sent and to annex a copy thereof to the particulars of claim. If you do not briefly elaborate on the demand made, the defendant may deny that it received any such letter. So, in the next paragraph, we will state, the plaintiff demanded payment from the defendant on 12 November 2021 by way of a letter of demand, a copy of which is annexed here to marked C. Alternatively, the summons serves as written demand for payment. I often like to add that in the alternative, the summons serves as a written demand for payment. Be very careful about demand. The terms of the agreement are crucial, and so are certain legislative provisions. Remember Section 129 of the National Credit Act. It is often that a formal demand or written notice is required before legal action may be instituted. In such an instance, compliance with the agreement or legislation is imperative, and such compliance must be alleged in your particulars. Finally, we need to indicate whether or not our client has elected to cancel the agreement due to the defendant's breach. For purposes of our example, the plaintiff elected to cancel the agreement in a written notice to the defendant before we received the instruction. The terms of the agreement are also very important when it comes to cancellation of the agreement, so be careful. In our cancellation paragraph, we will state, on 22 November 2021, and as a result of the defendant's breach, the plaintiff notified the defendant in writing of its election to cancel the agreement. A copy of the cancellation notice is annexed hereto marked D. Alternatively, the summons serves as written notice of cancellation of the agreement. As you can see, I have also stated that in the alternative, the summons constitutes notice of the plaintiff's election to cancel the agreement. Again, the terms of the agreement are very important in this regard. Bear in mind that you won't always be cancelling the agreement, as you may be demanding specific performance, for example. The paragraphs pertaining to breach look as follows. We are now essentially done with our particulars of claim. All we have left to do is set out the relief which the plaintiff seeks. As you should know, the relief sought is also known as the prayers. Prayers. As mentioned already, the prayers refer to the relief sought by the plaintiff. We do not insert a subheading for the prayers. Instead, we will say, wherefore the plaintiff prays for judgment against the defendant in the following terms. We will then set out the specific relief sought in number format. Take note that when there are several defendants against whom you are claiming the same relief, you will state something like, wherefore the plaintiff prays for judgment against the defendants jointly and severally as follows. There are various different ways of setting out such a sentence, which can be dependent on what the agreement says, but we'll get to this in a later episode. Now, what exactly is the relief we seek on behalf of the client? Well, we know that the defendant owes our client 500,000 Rand at the very least, so prayer 1 will be payment of the sum of 500,000 Rand. Take note that you do not have to use this exact wording. Is the payment to set out above the only relief we seek? No. Let's go through the material terms of the agreement, which we have set out in our particulars of claim, and see whether we need to claim further relief. Have a look at paragraph 5.7 of our particulars, which says, without prejudice to any of the other rights of the plaintiff, from due date to date of payment, the defendant shall pay interest on the annual prime rate of interest as determined by Standard Bank of South Africa Limited from time to time during the period while the payment is outstanding on all amounts due by the defendant to the plaintiff in terms of or arising out of the agreement. It is clear from this paragraph that we can also ask for interest on the capital amount, but at what rate? Well, the paragraph says the annual prime rate of interest determined by Standard Bank. So, what is the current prime rate of interest? Google is your friend. The current prime interest rate is 7.25%. When a clause in an agreement doesn't refer to a specific interest rate, but rather the prime rate, etc., make sure to use the current prime rate. Therefore, in the relief we seek, we need to add a second prayer for interest on the amount of 500,000 Rand at the rate of 7.25% per annum. Make sure to clearly state whether the rate of interest is per month or per annum. Our second prayer is incomplete. We haven't indicated the duration for which the requested interest is to run. This we need to do, so again, have a look at the interest clause as set out in our particulars. The paragraph states that interest will run during the period while the payment is outstanding on all amounts due by the defendant to the plaintiff in terms of or arising out of the agreement. In simplified terms, this means that interest will run from the date on which the defendant defaulted on payments until the full outstanding balance is settled. That being said, what will our interest prayer look like? We will word our interest prayer as follows. Interest on the aforesaid amount at the rate of 7.25% per annum et tempora more to date of final payment. Don't stress about the use of the phrase et tempora more. This is a Latin phrase which basically means from the moment the debtor is in default. You of course don't have to use this phrase and can instead word the entire interest prayer in English. Take note that the wording of your interest prayer may vary. You can word it exactly as it is cited in the agreement, or you can change it slightly, as we have done. As long as the actual rate of interest and the duration for which it will run are correct, you should have no issues. What further relief do we need to request from the court? Again, let's look at the material terms of the agreement, which we have mentioned in our particulars. What does paragraph 5.11 say? It says that, in the event of a breach as aforesaid, the plaintiff would be entitled to recover all legal costs incurred by it, including attorney and client charges, tracing fees, and such collection commission as the plaintiff is obliged to pay to its own attorneys from the defendant. The costs would include, but not be limited to, costs incurred as from the date that the plaintiff instructs its external attorneys for dispute resolution, debt collection, and/or agreement enforcement. Attorneys are not cheap, we all know this. Don't you think it seems a bit silly having to pay a fortune in legal fees just to recover a debt owed to you? Of course. That's why, in almost every summons, there'll be a prayer for costs. Usually, a winning party will be entitled to recover from the losing party a portion of the legal costs incurred by them. This is not always the case, however. We will not be going into depth here, but costs can be awarded on three scales, namely party and party, attorney and client, and attorney and own client. Costs which can be recovered are subject to tariff, with the least desirable scale of costs being party and party, and the most favorable scale being that of attorney and own client. Attorney and client costs and attorney and own client costs are usually recoverable where there is an agreement expressly stating that any legal costs incurred will be payable on either of the aforesaid scales. In our example, the agreement features a clause stating that the plaintiff will be entitled to recover all legal costs incurred by it, including attorney and client charges. We can therefore see costs on this scale. The next prayer will read, costs on the attorney and client scale. In most matters, regardless of whether there is an agreement in place between the parties, you will pray for costs. It's only the scale that will be different. We have now set out the entire extent of the relief our client seeks. It is, however, standard to insert a prayer for further and/or alternative relief, so we'll do just that. Our prayers will therefore look as follows. All we need to do now is sign off. Signing off. At the end of every pleading, we need to indicate the date on which the particulars were signed, as well as the place at which they were signed. We must also include the plaintiff's attorney's details, such as its address, contact numbers, etc. Let's quickly look at Rule 18, Subsection 1 again. In terms of this rule, the particulars of claim shall be signed by both an advocate and an attorney, or, in the case of an attorney who has the right of appearance in the superior courts, only by such attorney, or, if a party sues or defends personally, by that party. Put simply, the particulars of claim must be signed by an attorney with rights of appearance in the superior courts, alternatively by an advocate. Remember, this rule only applies to high court pleadings. Pleadings in the Magistrate's Court may be signed by an attorney, regardless of whether they have rights of appearance in the superior courts. We will pretend that the attorney in our example has right of appearance in the superior courts. The signing off portion of the particulars will therefore look as follows. You will note that provision has been made for the signature of Raymond Donovan, as well as the plaintiff's attorneys, which is the firm at which Raymond Donovan works. The signatory section of the particulars is set out in such a manner so that the attorney with right of appearance identifies themselves and confirms that they are admitted in terms of Section 25 of the Legal Practice Act. Below the signature of the attorney with right of appearance is a place for the signature of the plaintiff's attorneys. An admitted attorney without right of appearance may sign here. However, it may be easy just to have the attorney with right of appearance sign in both spots. And that's that. We have drafted our combined summons. Final steps. All that we have left to do is compile the combined summons. This means that we must attach the particulars of claim to the summons and attach and mark the annexes to the particulars of claim. We obviously need to sign the summons and the particulars of claim as well. Once the aforementioned has been attended to, you can make the necessary copies and drafted documents to accompany the summons for issuing. For more information on issuing, etc., check out our episode on the formalities of the summons. A High Court combined summons template can be found in the Google Drive folder linked in the description. Magistrate Court combined summons. Before I conclude this episode, I want to briefly set out the extent to which a combined summons in the Magistrate Court will differ to that in the High Court. Regarding the summons component of the combined summons, the only difference in the heading will be the court out of which we are proceeding. Let's pretend we are issuing summons in the Roodepoort Magistrates Court. The court's particulars will be in the Magistrates Court for the Magisterial District of Johannesburg West, held at Roodepoort. The remainder of the summons heading will stay exactly the same. The heading will therefore look as follows. The citation of the parties will also remain exactly the same. A change that we need to make throughout the summons is to replace all references to registrar with clerk, as we are in the district court. Remember, in the regional court, we use registrar. We will also need to amend the paragraph wherein reference is made to the address of the court. As we are no longer in the Johannesburg High Court, the address will be different. The rules referred to in the summons will also need to change, as the uniform rules of court are no longer applicable. Considering the above, the address which the defendant will set out in its notice of intention to defend will be in terms of Rule 13 subsection 3 instead of 19 subsection 3. The adjusted paragraph in the summons will look as follows. Our indication that the plaintiff agrees to service via email will now be in terms of Rule 5 subsection 3b. This paragraph will look as follows. Rule 5 subsection 5a and b are responsible for the main difference between High Court and Magistrate Court summonses. This rule provides that every summons shall include a form for notice of intention to defend, and every summons except a divorce summons shall include a form for consent to judgment, a notice drawing the defendant's attention to the provision of Section 109 of the Act, and a notice in which the defendant's attention is directed to the provisions of Sections 57, 58, 65a, and 65d of the Act, in cases where the action is based on the debt referred to in Section 55, which is the liquidated sum of money of the Act. Although not expressly required, we must still include the table of costs at the end of the summons. Remember, we will need to set out the costs of the summons and judgment, as well as the VAT thereon. With regards to the particulars of claim, they will be exactly the same in the High Court and the Magistrates Court, save for the amount claimed being less in the Magistrates Court. There's also obviously the signature section where an advocate or an attorney with rights of appearance will not need to sign. Thanks for tuning in, guys. You should now be able to draft a combined summons where the cause of action arose out of a breach of an agreement. If you want me to do more episodes on drafting summonses based on various causes of action, let me know in the comments. If you haven't already, please hit that subscribe button and share our channel with your friends. Most of our viewers are still not subscribed, so guys, please. See you soon.